Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr Law Firm. And I'm your host, Alan Kaplinski, the former practice group leader for 25 years and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'm very pleased to be moderating today's program. For those of you who want even more information, either about the topic that we're going to be talking about today or anything else in the world of consumer financial services, please don't forget about our blog, consumerfinancemonitor.com. We've hosted our blog since 2011 when the CFPB became operational. There's a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you access your podcasts. And also, please let us know if you have ideas for any other topic that we should consider covering on a future podcast show or speakers that we should consider as guests on our show. The podcast show that we are releasing today is part one of a two-part repurposed webinar that we conducted on September 24th. The title of our webinar is A New Era for Banking, What President Trump's Debanking Executive Order and Related State Laws Mean for Financial Institutions, Government, and Banking Customers. The topics that we're going to cover today are the history of debanking, including Operation Chokepoint, and a final regulation that was issued by the Comptroller of the Currency during the waning days of the first Trump administration regarding debanking for the very largest banks. That regulation was finalized, but it never got published in the Federal Register and therefore never formally became a regulation. We're also going to be talking about the elements of President Trump's debanking executive order. And finally, today, we're going to be talking about the statutory authority, or as I believe, the lack of statutory authority for the executive order. So, to get into it, on August 7th, President Trump signed Executive Order 14331, titled Guaranteeing Fair Banking for All Americans. The order seeks to prohibit financial institutions, regardless of their size, regardless of whether they're a bank or a non-bank, from denying services to individuals or entities based on their political or religious beliefs or orientation, or the lawful businesses in which they are engaged. This landmark action is poised to reshape the landscape of banking compliance and risk management, with federal regulators now being directed to combat politicized or unlawful debanking. Financial institutions, businesses, banking customers, and legal and compliance professionals must understand both the immediate and long-term implications. And during the next 90 minutes, we are going to cover the waterfront on this executive order. We're going to talk about some state laws that deal with fair access or debanking that have been enacted within the past few years. We're going to talk about how the agencies have reacted so far to the executive order. We're going to talk about what I consider the very shaky legal foundation of this executive order. And we'll get into an explanation of why we believe that, at least some of us believe that to be the case. Before I introduce our speakers, let me just say, we are not new. I mean, when I'm talking about new, I'm talking about our Consumer Financial Services Group, our podcast show, and our webinars to this subject of debanking. We have dealt with it on numerous occasions, and indeed, Brian Knight, who is one of the guests on our show, has been a guest on our podcast show not too long ago. And he was there with Professor Peter Conti Brown of the Wharton School at Penn. And we had a very, very heated discussion about state fair access and debanking laws. Also, I was very privileged to have Julie Hill, a professor at University of Wyoming Law School, talk about reputation risk and a law review article which she had written about it well before the executive order got issued. And we did another podcast show also last year dealing with Operation Chokepoint 1.0. So let me now turn to our speakers. And first, I'm going to start with Will Hild. Will is the Executive Director of Consumers Research, the nation's oldest consumer protection organization, but I should add, with a very definite conservative orientation. I think it's important to make that point. Although I did find out today in talking to Will that Consumers Union, which publishes consumer reports, is an offshoot of Consumers Research. A big focus of Consumers Research has been ESG, the dangers of ESG, and woke capitalism. And another area of concentration is the topic we're talking about today. Brian Knight is Senior Counsel, Corporate Engagement of a nonprofit organization called Alliance Defending Freedom. Brian serves as Senior Counsel on the Corporate Engagement team. His work focuses on issues of financial access, debanking, and preventing the power of the private sector from being weaponized against people of faith by both public and private actors. Prior to joining Alliance Defending Freedom, Brian spent almost 9 years at the Mercatus Center at George Mason University as both a senior research fellow and as a program director. Then I want to introduce Jason McCullough. Jason is an independent fintech and banking advisor, a consultant, and investor. He also is the best-selling author of, and I'm putting this as the name of the book, Banking as a Service. And he was my guest on our weekly podcast show, Consumer Finance Monitor, to talk about his new book on February 20th, 2025. And if you at all deal with banking as a service, which is what his new book deals with, that is joint ventures that exist between banks and non-banks to offer banking-like services, his book is a must-have. It is a great read. Jason's also the publisher of FinTech Business Weekly, a newsletter going beyond the headlines to analyze the technological, regulatory, and business model trends driving the rapidly evolving financial services ecosystem. Previously, Jason spent over a decade building and scaling consumer finance businesses, including such companies as Enova, LendUp, and Goldman Sachs, which of course diversified into the consumer finance area almost a decade ago. And then I want to introduce Todd Phillips. He's an assistant professor of law in the Robinson College of Business at Georgia State University. His areas of expertise include bank capital, prudential regulation, deposit insurance derivatives, securities market structure, and the laws governing federal financial regulators. Before entering academia, Todd served as an attorney for the FDIC, the Administrative Conference of the United States, the U.S. House of Representatives, and the Center for American Progress. He has testified before Congress on several occasions, and he has written in many, many law review articles, and he's quoted frequently in all the major newspapers, including New York Times, Washington Post, Politico, etc. Then finally, last but not least, let me introduce Graham Steele, an academic fellow at the Rock Center for Corporate Governance at Stanford Law School. He's also a fellow at the Roosevelt Institute, a nonpartisan think tank that advances progressive policies that bring the legacy of Franklin and Eleanor Roosevelt into the 21st century. He's an expert on financial regulation and financial institutions with experience working at the highest levels of law and policy in Washington, D.C. He was confirmed by the U.S. Senate in November 2021 to serve as Assistant Secretary for Financial Institutions at the U.S. Department of the Treasury. I could go on, but I want to get into the guts of our program today. So let me turn you over to Jason, who's going to talk about the history of banking.
Thank you for that lovely intro, Alan. Very excited to be here. I'm going to hop right to it because I think we have about 10 minutes for this section, and I do want to make sure that the other panelists have an opportunity to chime in. First, I think it's worth establishing that, at least as far as I'm aware, there is no established legal definition of the term debanking, although it is typically understood to mean when a financial institution closes or declines to open an account for businesses or individuals due to perceived legal, regulatory, reputational, or other risk-based reasons. President Trump's August executive order on the topic does offer a specific definition, which I believe Todd is going to cover as part of the next section. Excuse me. The ambiguity around the term debanking has allowed stakeholders across the political spectrum to tag on to it to advance their own PR or policy priorities, making the term, I would argue, perhaps not the most useful one. To sort of delve into some of the current discussion around it, I sort of pinpoint the current conversation is really accelerating when Marc Andreessen, best known as the venture capitalist who founded A16Z, appeared on the Joe Rogan podcast in December 2024, where he falsely claimed that the CFPB was responsible for debanking individuals and businesses in industries out of favor of those holding political views that were unpopular with the prior administration. I would point out that Andreessen and his firm are significant investors in fintech and crypto companies, including historically payday lender that I actually worked for, LendUp, as well as strongly supporting Trump during his second campaign for the presidency. So it's not exactly like an unbiased appearance he made on the Joe Rogan podcast. But it's worth pointing out, the threads of what Andreessen brought up during that Joe Rogan interview and the subsequent political debate go back at least 25 years, if not further. I'm going to try to speed through this because there's a lot, but I would really at least date some of this to the early 1990s and, yes, payday lending, where as states began cracking down on payday lenders, they began seeking to partner with OCC chartered, nationally chartered banks in order to circumvent state rate caps by taking advantage of preemption. By the early 2000s, under both President Clinton towards the tail end of his administration and President George W. Bush, federal banking regulators, specifically the OCC and the Office of Thrift Supervision, began to apply increased scrutiny and pressure to banks and their third-party payday lending partners. For example, the OCC issued an advisory letter in November 2000 that encouraged banks that were operating such partnerships to do so in a safe and sound manner, not to engage in abusive practices that would increase compliance, legal, and reputation risk associated with payday lending that could harm the bank's customers. At that time, that advisory flagged credit risk, transaction risk, reputation risk, compliance, legal, so on, specifically flagging relevant regulations like ECOA, TILA, FICRA, EFTA, TISA, and lending limits. So ultimately, you saw a lot of nationally chartered banks wind down, exit those relationships. You had a couple more waves with state chartered banks, and a lot of that payday lending partnership business didn't go away. It migrated to tribal and offshore. That's a different webinar. You mentioned Operation Chokepoint 1.0 in your introduction, Alan. I would argue, based on my understanding, that Chokepoint, at least as it's being discussed today in 2025, is widely misunderstood and has been greatly exaggerated in its scope and its significance. It's taken on this almost mythical status as a shadowy conspiracy. But the reality is, Operation Chokepoint was formed in the aftermath of the 2008 financial crisis to focus on risks associated with third-party payment processors that were facilitating excessive volumes of fraudulent transactions. The initiative was looking for telltale signs of consumer fraud, like high rates of ACH returns, card disputes, and focused on, yes, higher risk merchants and billers, including payday lenders, online pharmacies, adult services, firearms, and so forth. It was hoped at the time that efforts from the DOJ with moral suasion and from bank regulators would encourage banks to more carefully vet their customers, the payment processors' customers, reducing the risk to consumers. The focus was to choke off illegal fraud schemes, though the effort did result in some legal businesses losing access to payment processing. Ultimately, there was an Office of Inspector General report from the FDIC reviewing Operation Chokepoint, and it found, with the exception of payday lenders, quote, no instances among the financial institutions the OIG reviewed where the FDIC pressured an institution to decline banking services to a merchant on the high-risk list. Further, bank executives that the OIG spoke with indicated that, except for payday lenders, they had not experienced regulatory pressure to terminate an existing customer relationship with a merchant on the high-risk list, including firearms, ammunition, and tobacco retailers, end quote. I want to make sure I get in my last bit, which was the 2021 OCC Fair Access Rule, which was finalized but did not go into effect at the tail end of the Trump administration. It would have required banks with more than $100 billion in assets to provide financial services to customers in their markets on equal terms, prohibiting broad denials based on political, industry, or reputational considerations unless justified by objective, risk-based criteria. Banks would have been prohibited from refusing services to entire categories or industries, for example, fossil fuel companies, gun manufacturers, or payday lenders, unless individual customers fail to meet objective risk-based standards. I will add one more point, and then I will open this up to the rest of the commentators. It's worth noting that at the time that OCC Fair Access Rule was being formulated in 2021, the major bank trade groups were staunchly against it. The BPI, which represents the largest banks, said at the time, quote, the OCC claims to be shielding customers from political bias, but it is just telling banks and their boards that they cannot be trusted to make sound business decisions. And BPI President Greg Baer said, quote, the rule lacks both logic and legal basis. It ignores basic facts about how banking works. Its substantive problems are outweighed only by the egregious procedural failings of the rulemaking process, and for these reasons, it is unlikely to withstand scrutiny. And I'm at about 8 minutes, so I will relinquish my time so that others have a chance to rebut or push back on my characterization.
Thank you, Jason. I'm going to call on Brian, but before I do, let me just mention that while the OCC issued that final rule that you identified, it never became an effective final rule because it never got published in the Federal Register. And the reason it didn't get published in the Federal Register is that it got issued right before the end of one administration and before Trump 1.0 became effective, shortly after it was sent over to be published. So I should say I got that wrong. It was issued during Trump 1.0, but then when the Biden administration took over, they deep sixed that regulation. Brian, you'd like to comment?
Yep. So I will push back on Jason a little bit in that, one, I think as we flesh this out, there is also an example where the FDIC went after refund anticipation loans and drove banks, which are legal products, drove banks out of that market. Like 100% of the banks that worked with refund anticipation lenders stopped working after the FDIC went after them. And the FDIC, relying on moral suasion and reputation risk because they didn't have a good legal basis, threatened to basically use the supervisory process incredibly painful. We also saw, the FDIC OIG report described something similar with the case of payday loans, but we should also acknowledge the methodological limitations of that OIG report. They interviewed the one on Operation Chokepoint. They interviewed 25 banks. So, that's actually that's too small a sample size to take advantage of the law of large numbers, right? Like, if I recall from statistics, you really want about a minimum of 30 to start making any sort of statistical inference. And so, I'm not saying that's right or wrong. We don't know, but we have to be thinking about it. And then on the fair access question, one, I'm not surprised the Bank Trade Group opposed bank regulation. That would not be shocking. But two, what that was also coming in the wake of several large high-profile banks making these grandiose announcements saying, in effect, there should be more gun control. We need immigration reform. We want to be part of the net zero transition, and we are going to condition access to our services on that basis. And a recent Wall Street Journal article confirmed, that at least some of the executives interviewed said, part of what we are motivated by is the desire to speed social change. Speed, not reflect, accelerate. And so that's part of what is inspiring this, this concern about debanking. It's not just the regulators behaving badly, which is a totally legitimate concern. And the EO speaks to that, but also that banks are using the privileged position they're given by law to try to direct or force or speed social change. And that is part of what's getting so much pushback and why we're seeing so much pushback from, the right, for lack of a better word.
Yeah. Okay. We're going to go, because we have a lot to cover. I'm going to go next to Todd, who's going to tell us about what's in the executive order.
Great. Thanks, Alan. So really quickly, the executive order has roughly 4 different elements. The first is the purpose. The EO says that individuals, their businesses, and their families have been subjected to debanking on the basis of their political affiliations, religious beliefs, or lawful business activities. The EO then talks about how they've suffered frozen payrolls, debts, crushing interests, and argues that such practices are incompatible with a free society and the principle that provision of banking services should be based on material, measurable, and justifiable risk. I'm going to provide a little bit of opinion right there, which is that I don't think there's anything in statute that says that that's what the purpose of banking is. Anyway, the second part of the order talks about policy. It argues that no American should be denied access to financial services because of their constitutionally or statutorily protected beliefs, affiliations, or political views. The purpose of the EO is to ensure that politicized or unlawful debanking is not used as a tool to inhibit such beliefs, affiliations, or political views, and that banking decisions instead must be made on the basis of individualized, objective, and risk-based analysis. So that's the purpose and the policy. Now let's get into the scope. The EO hinges on the term politicized or unlawful debanking. And it defines this term by saying that it's an act by a financial services provider to directly or indirectly adversely restrict access to accounts, loans, or other banking products or financial services on the basis of the customer's political or religious beliefs or disfavored political reasons. So again, everything hinges on politicized or unlawful debanking, which is the restriction of banking services on political or religious beliefs. It defines the term federal banking regulators much more broadly than we would expect. It applies to the banking agencies, of course, the Fed, OCC, FDIC. It also includes in that category the NCUA and the CFPB and Small Business Administration. So although it talks about banking regulators, it's much broader than that. Finally, the actions. It calls for each of these regulators to remove the use of reputational risk or equivalent concepts that could result in politicized or unlawful debanking. The agencies have mostly or entirely done that. Second, it says that Treasury shall develop a comprehensive strategy for further measures to combat politicized or unlawful debanking activities, including legislative and regulatory options. And it requires each regulator to identify the financial institutions that have had past or current policies or practices around politicized or unlawful debanking, to take remedial action, including fines, consent decrees, other disciplinary actions. And it calls for the specific enforcement of several statutes that we're going to talk about. To editorialize again, and then turn it over to the group, I want to call out the fact that this term is politicized or unlawful debanking. I think it's clear from that politicized does not necessarily mean unlawful. It separates out the two terms. And I think that's something we should talk about whether politicized debanking is the same thing as unlawful debanking.
Okay. Well, one thing I want to just mention, and then I'm going to turn it over to others who want to comment, is that in telling the regulators and telling the financial institutions that they have to go look back at what they have done historically, no, they haven't given any indication yet as to how far back they have to go. Is it a year, 2 years, 5 years, 10 years? Is it since they began business? It's hard for me to believe that somebody who was putting together this EO for the president didn't focus on that very fundamental question, which I must have had 24 clients raise that issue with me as to how far back they have to go. I think I saw, did I see your hand, Will?
Yeah, I had a quick comment, more of a question for Todd, actually. I just wanted to make sure, you may have said this, Todd, because you were doing a very good job of going through everything, but I didn't catch it. Did you mention that it also directs the banking regulators to remove reputational risk as a risk factor?
Yes.
Okay.
Yeah, I did. And I said that
there's a deregulatory component to this as well, one might argue.
Yeah, so I think Todd's right that politicized debanking and unlawful debanking are a Venn diagram that can look like this. In most jurisdictions, your politics is not a protected class. In most jurisdictions, speech is not a protected class. But I also think it's important to bear in mind, and we're going to probably get into this more later, that part of what this EO is meant to be is a fact-finding operation because banking is so opaque by design. And so, it's not that the administration is going to punish people for actions that were lawful at the time they were taken. But as we get more transparency, more information, that will help us as the American people have a debate about, well, what should be legal, what should not be legal. And so that's a big part of what I think this EO is trying to accomplish, is feed the democratic process with more information about what do we need to do, if anything, on the areas that aren't previously covered.
Yeah, I would just note that similar to the ESG fight that our organization spends a lot of time on, there's two reasons why it's very hard. It's not necessarily apparent when there's been a case of debanking. One is that banks were using KYC regulations to argue why they shouldn't or couldn't give total understanding to the client about why they were being canceled. The other reason is that oftentimes we saw in the ESG space that it basically functioned like a shakedown operation. There was a case where Credit Suisse, rest in peace, had asked a oil executive to tweet out from his personal account political statements related to climate change in order to maintain his line of credit with the bank. Now, there's an inherent intimidation factor related to that. Now, this banking executive, Bud Brigham, luckily was, courageous enough to testify under oath that this happened, and the bank employee themselves was stupid enough to put it in writing, so they had hard evidence of this occurring. But my point, to Brian's point, I agree. Part of this EO is to get a handle around how bad this is because it's operated in the shadows, and it's operated both in the shadows and through intimidation, often cases, so people don't feel comfortable, necessarily raising their hand that they've been abused.
Yeah, Todd?
I want to just comment on Brian's note that this is fact-finding. I'm not too sure that this is just a fact-finding exercise. The EO itself calls for leveling fines and issuing consent decrees and imposing other disciplinary measures. And I think we have to remember that this is happening in a climate where the administration has taken efforts to impose fines, issue consent decrees against universities, against law firms, against other disfavored industries. And so while we have yet to fully see everything that is going to unfold from this executive order, if I was a bank, I would be fairly worried. I also think that if I was a bank, I would probably have pretty strong grounds to push back against the regulators if I went to court. But as we've seen from some of the other industries, the private sector isn't too interested or willing to do that.
So, Alan, if I could just say one thing real quick for context. The relevant section of the EO says, levying fines and issuing consent decrees and imposing other disciplinary measures against any financial institution subject to the jurisdiction of such federal banking regulator, that such federal banking regulator finds has engaged in politicized or unlawful debanking that violates applicable law. And then it cites Section 5 of the Federal Trade Commission Act, Section 1031 of the Consumer Protection Act, and the Equal Credit Opportunity Act. Yep. So there isn't some wide-ranging authorization to go do fines and stuff like that in the EO. Not that such a thing could exist, but if they discover that, hey, this particular version of politicized and unlawful debanking that you conducted does run afoul of an existing law, then they're being directed to sort of prioritize that as an enforcement action.
Yeah, that's a good segue.
Should I talk about? Yeah,
I want to go to Graham now, and it's a good segue because the next topic we're going to talk about is statutory authority or lack thereof. And you just mentioned, Brian, the 3 statutes that are cited in the EO, and Graham is going to elaborate on that.
Great. Thanks, Alan. Yeah. And I'm going to focus on banking law since I'm not familiar. There's a whole SBA component of this, and I will confess I'm not really familiar with what all the accusations against SBA are here. But because everyone, or at least most of the folks on this call, are lawyers, let me start with an obvious observation, which is this executive order cannot create some sort of new law here. There's been some confusion based on some of the other previous executive orders, but let's just be clear about that. They've got to rely on some sort of statute that they're ostensibly trying to interpret here or urge the agencies to interpret. And so that previous 2020 Fair Access rule that Alan, you, and Jason were talking about, that was one of the issues that rule had, was they relied on Section 1 of the National Bank Act and a broad charge to the OCC financial services without any more specific authority than that, which was very, very problematic as a reason to then try to base some sort of supervisory or enforcement mechanism on. And so to its credit, this executive order seems to get that prior version in doing it that way wasn't going to work. And so they rely in particular on three sources of statutory authority. One is the Equal Credit Opportunity Act, or ECOA, which makes it unlawful to discriminate in credit on the basis of race, color, religion, national origin, sex or marital status, age, disability, or because a person receives public assistance. And the order is sort of interesting to Todd's sort of point about unlawful versus political debanking. It sort of switches back and forth between making claims about people being debanked for religious purposes or for political purposes. And it's very clear to sort of say, well, religion is clearly covered by ECOA, but then there's a little bit of sort of hand waving or hide the ball about, well, when political debanking are on the basis of sort of politics, when they're sort of talking about religion versus politics, and to just make it explicit, some of the groups that have claimed to have been debanked, fossil fuel companies, gun manufacturers, or crypto, just are not members of protected classes protected by fair lending law and don't have some sort of constitutional guarantee of access to the banking system. So that's point number one on ECOA. Point number two, the EO alludes to the general supervisory process under Safety and Soundness Authority in Section 1818 and Title 12 of the U.S. Code. Very broad provision, and as I think Will flagged, talks about reputational risk in particular. And it seems to me that, modifying the way in which the agencies use reputational risk well within the agency's discretion to do. So while I think that the general recommendation and the legal basis for that is generally fine, I think the claims about how reputational risk is used can sometimes be overstated, usually when you actually unpack what's going on. It is not the sole factor that is being used. There's some sort of other underlying risk management or compliance issue the bank has used that also sort of blends into reputational considerations at the same time. I don't think there are other safety and soundness hooks here. What I will also just observe is that there's an interesting way to me in which, to the extent that this executive order is trying to incorporate politics as a consideration, it could actually run afoul of traditional safety and soundness principles and override banks from trying to make decisions based on what they think is sound risk management, which could actually undermine safety and soundness. And then the last source I'll point out, which Alan, you are well versed in and wrote a great blog post about, is unfair, deceptive act or abusive acts and practices under the FTC Act and the CFPB Act. And I'm very curious to hear what everyone else thinks. Alan, some of your thoughts are on the record. But I actually think there are interesting arguments here that those authorities could apply in hypothetical situations where banks unilaterally close customers' accounts. On the one hand, again, as Alan knows well and laid out well in that blog post, CFPB clearly said that discrimination is not part of UDAP. And so to the extent that this executive order tries to frame debanking as a form of discrimination, you've got a conflict with the CFPB's own interpretations and the extent to which UDAP authority could apply to various debanking situations. On the other hand, just you read on their face at a broad level, unfairness is an act or practice that causes or is likely to cause substantial injury to a consumer that isn't reasonably avoidable, and there is not some sort of countervailing benefit here. And then you look at the abusiveness prong, which is an act or practice that takes unreasonable advantage of the reasonable reliance by the consumer on a financial company to act in the interest of the consumers. I think you could imagine a view of debanking where there's a substantial injury to a consumer from a sudden account closure the consumer can't avoid, or where a bank's sudden account closure is seen as taking advantage of consumers who have thought the bank was going to act in their best interests. But I think, again, even there, you've got a problem because there are other laws like the Bank Secrecy Act or IEPA, the International Emergency Economic Powers Act, that actually require banks to close customer accounts if there's suspicious activity or they believe the customer might be violating sanctions provisions. And so neither of these broad theories about UDAP authority can necessarily override individual cases where a bank might think that there are violations of BSA or IEPA. The other thing I will just observe at a higher level is one wonders how CFPB is going to enforce UDAP authority now that it's been gutted. But I guess that's for this administration to sort of figure out how they're going to do the supervision and enforcement of this. And then real quick, Alan, one last point I would want to call out is that This EO departs from some past administrative practice in a way that could be significant. On the one hand, we're living in a post-Chevron world, again, as your blog post points out. So courts aren't supposed to be giving these agencies deference for some of their far-out interpretations of their authority. But this executive order uses more forceful directive language that past EOs have not used towards ostensibly independent agencies, where they tended to encourage agencies in the past. Here, there's a direct order. Here, the agency shall do this or do that, which, leaving aside whether or not I believe the president should be ordering around ostensibly independent agencies, which would have been appropriate in the past. Could courts look at the fact that this order, that some of these agencies' actions came from a directive of the president, actually mean that they would give them deference in this case? I'm not sure of the answer to that, but to me, there's just an additional layer of uncertainty there based on where we are in terms of administrative deference and the fact that the president's telling agencies to do this.
Graham, thank you. Let me add a little bit of a flavor to what you said, because there's a great irony, I believe, in the fact that the administration is using the unfairness prong of the Section 5 of the Federal Trade Commission Act, which we colloquially refer to as UDAP, Unfair and Deceptive Acts and Practices. And I think it's Section 1031 maybe of the Consumer Financial Protection Act, which is part of Dodd-Frank, which conferred on the CFPB UDAP authority, WDAAP authority, adding the abusive prong. So this was what happened was that the CFPB had an exam manual that it amended several years ago. And it was called the UDAP exam manual, UDAAP. And it laid out for companies being examined by the CFPB what the CFPB was going to be looking at in terms of unfair, deceptive, and abusive acts and practices. And so it amended the definition of unfairness to include discrimination. There was a hue and a cry among the bank trade associations, on anybody involved in banking, the banking lawyers, that were complaining about that and basically saying, how could you all of a sudden, out of whole cloth, define unfairness to include discrimination? And they relied principally on something called the major questions doctrine of the Supreme Court that basically said you should not defer to, and this is before the Loper-Bright opinion came down dealing with whether you need to give Chevron deference to an agency. And it basically said, if you've got a very broad term in a statute and there's no indication in the legislative history or elsewhere that there was an intent to encompass something as specialized as discrimination, you couldn't all of a sudden, there was no deference should be given to an agency who's going to make that kind of, in a sense, broaden the application of unfairness. Now, the two trade associations, Chamber of Commerce, and I think one bank, maybe the American Bankers Association, sued the CFPB in federal district court in Northern District of Alabama. Not going to comment on the separate issue of judge shopping or forum shopping, but let's say they were in front of what they consider to be a conservative Republican judge. The judge issued a fairly lengthy opinion in which he invalidated the amendments that had been made to the exam manual to encompass discrimination. And it was predicated principally on the major questions doctrine, that because of that doctrine, the Supreme Court would not tolerate that it was a definition essentially just pulled out of whole cloth when it comes to what UDAP means. That case then went up on appeal appealed by the CFPB, the old CFPB under Biden. The new Trump gets elected, he gets sworn in, and the new CFPB all of a sudden drops the appeal. Really, it was ready to be argued in front of the Fifth Circuit. They dropped the appeal because they didn't indicate why, but they just dropped it. Now, in things are being reversed. The shoe's on the other foot. Now, all of a sudden, they like the idea of using a broad definition of UDAP to encompass discrimination because it fits sort of comfortably with it. They needed some legal support for this executive order, and that's where they pulled it from. So, and the other thing I might mention, the trade associations, basically at least a couple of them or a few of them, support the executive order, whereas they litigated against it not that long ago. But anyway, Brian, your comment.
So I'm going to agree with Graham to some degree, which surprises me. Maybe it surprises him too. And I'm going to push back on you, Alan, a little bit in the sense that it is not yet clear that the Trump administration is adopting that broad view of discrimination as unfairness. I mean, I think Graham's correct that you can imagine specific facts and circumstances where a specific financial institution's decision to cancel an account or restrict access meets the criteria for unfair, deceptive, abusive, assuming you're talking about an individual rather than a corporate entity. And, enforcing those laws in that manner is entirely consistent with a view that Dodd-Frank did not become a universal anti-discrimination law. So, I mean, I think that's a circle that can be squared. We will have to see how this authority is used.
I wanted to add something else that might color a lot of this. We have to remember that there's constitutional due process, and the Supreme Court has said a number of times that if agencies want to bring enforcement actions against someone, they must have notice that what they have done is illegal. And I think it needs to be stated clearly that I don't think anyone, or at least certainly not me or other people I've talked to, have thought that these laws are used to prohibit account closures or to require banks to provide accounts. And I think that even though arguments feasibly could be made that, UDAP authority prohibits account closures or requires accounts, the fact that no one has thought about it before, that banks have not really ever thought that they had this obligation, means that the lawsuits would be very, very, I think, tough for the government to win, assuming that banks or the financial industry does decide to push back. Obviously, the UDAP case that Alan was talking about was about prospective change. And I think that prospective is very different from a retrospective enforcement actions. But I think that the due process issue here is one that kind of should cover everything.
Make sure you stay tuned for the release next Thursday of part 2 of our 2-part podcast series related to a webinar we conducted on September 24th called A New Era for Banking, What President Trump's Debanking Executive Order and Related State Laws Mean for Financial Institutions, Government, and Banking Customers. Next Thursday, we will be discussing a number of other topics, including areas of uncertainty with respect to the executive order issued by President Trump, the definition of, quote, religion, unquote, what regulator will issue regulations or other guidance, the intersection with the Anti-Money Laundering Act and the Bank Secrecy Act, the intersection with state debanking statutes and the experience that the states have had under their statutes, pending federal legislation, and what should financial institutions be doing now to prepare for regulator review. I consider that to be the most important thing that we will discuss. And then finally, is this executive order good or bad policy? And is there a proven need for the executive order? And we will explore that issue in detail. Stay tuned. To make sure you don't miss any of our future episodes, please subscribe to our show on your favorite podcast platform, Apple Podcasts, YouTube, Spotify, or wherever you listen. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights about the consumer finance industry. And if you have any questions or suggestions for the show, please email us at podcast, that's singular, at ballardspire.com. Stay tuned each Thursday for a new episode of our show. Thank you for listening and have a good day.